Ladies and gentlemen, dear colleagues and friends of the Käte Hamburger Center Law as Culture, it is a great pleasure for me to welcome you to today's lecture at our forum. Our speaker tonight is my esteemed colleague at the Faculty of Law here in Bonn, Professor Matthias Herdegen. The topic of his talk is the international law of biotechnology, personhood and human rights, risk management and international trade. The field of biotechnology has been experiencing developments at a dramatic rate throughout the last decades. What nobody dreamt of yesterday became possible today, and we can only venture at guessing what will be feasible tomorrow. These advances in biotechnology have a tremendous potential for improvement for human beings as well as for the environment. Curing chronic diseases with newly developed medicines, allowing to procreate through medically assisted reproduction, or reducing the use of herbicides by developing modified crops, just to mention a few of the possibilities. However, biotechnological developments also entail high and often unforeseeable risks, as well as potential for abuse. Thus, there is a strong international effort to secure minimum standards of regulation within the field of biotechnology. Meanwhile, there are a number of conventions and other instruments, both on the European as well as the global level, which aim to define internationally acceptable and accepted standards in various biotechnology fields, be it medicine, human embryos, or genetically modified organisms. To achieve any global standards in these areas is an extremely difficult project due to the diverging social, cultural, and legal norms with regard to both the potentials as well as the perceived dangers. Obviously, attitudes towards various methods of assisted reproduction or genetic modification of food vary from one society and culture to another. But also the willingness to take risks may differ, with the European Union's so-called cautionary principle aiming at the protection of consumers and environment, as opposed to the substantially lower standards, for example, in the US. Or are these diverging standards, which have led to a considerable disagreement during the CETA and TTIP negotiations, not expressions of different cultures, but merely the result of the respective market forces driving at lowering costs as well as lowering standards? Because obviously linked with biotechnology is not only the hope for improving human lives, but also the hope for substantial profits. But also having regard to reducing the barriers to free trade, surely some values must be deemed universal, namely the dignity of the human being, which might be at risk by biotechnological advances. However, even with such a concept as human dignity, which at the first glance seems to be a universal notion, one must wonder, when human life begins or is considered to end, vastly differs from one culture or religion to another. This results in divergent ethical standards as well as legal norms when considering, for example, the situation of surplus embryos, that is, embryos which have been created for implantation but are no longer needed for this purpose. Can they be discarded, used for research, or even traded? Or can and should they be donated or adopted? Questions such as these will most certainly not be answered in the same way in different cultures and religions or legal systems. Thus, the challenges which the international law of biotechnology faces today is not only a highly fascinating subject, but also one of utmost interest here at our Center Law as Culture. Before our expert in this field, Professor Herdegen, will acquaint us with the complexities of the topic, let me introduce him first. Matthias Herdegen holds a chair for public, European and international law and is director of the Institute for Public International Law as well as the Institute for Public Law at the University of Bonn. He is also a member of the board of the Center for European Economic Law, director of the Studies in International Economic Law and co-director at the Center for International Security and Governance. He studied law in Heidelberg, where he also obtained his doctoral degree and finished his habilitation, immediately followed by the offer of a position here in Bonn. After a brief period at the University of Constance, he returned to Bonn in 1995, where he has remained since. Professor Herdegen has published extensively in his various areas of research with an overall of approximately 200 publications, including articles in German, English, and Spanish. His well-known German textbooks in international and European law mark his fields of expertise, as does, for example, his handbook on international economic law, published by Oxford University Press. His books have been translated into many languages, including Chinese, Japanese, Spanish, and Polish. He has also published profusely in the field of international regulation of biotechnology, which will be our focus tonight. Especially relevant in this context is also his well-known commentary on Article 1, Paragraph 1 of the German Constitution, which protects human dignity, in the handbook of Mount Zurich that he is co-editing. Matthias Herdegen's academic achievements have been recognized by several honorary doctorates from universities in Colombia, among others the Pontifical University in Bogota, where he's also honorary professor. Furthermore, Matthias Herdegen has been visiting professor at many renowned universities worldwide, has been advising legislative and executive bodies in Germany as well as other countries, and is acting in numerous other functions and capacities. As listing all of them would probably take the rest of the evening, I will stop here and just then mention that Matthias Herdegen has been fellow at our center some years ago and is also currently here as a fellow. I'm very much looking forward to your presentation.
Thank you very much, Professor Detloff, for your very kind, generous, and inspiring presentation. Dear friends, co-fellows, and colleagues, I take great pleasure in sharing some thoughts, including some rather tentative thoughts, on a few selective salient issues which the recent developments of biotechnology present to law, especially to public international law, the implications for personhood, human rights, international trade, and patents. So I suggest that we discuss and focus on human dignity, on risk management, and if you like, that we briefly discuss patent issues. What are the salient issues which we face nowadays? The discussion on in vitro fertilization, already mentioned by Professor Detloff, the status of the embryo in vitro. Is he, she, it a kind of human person? The related issue of pre-implantation diagnostics. We had a very hot and passionate debate in the German Diet on this issue. The discussion on genetically modified crops all over the globe, which is most controversial in the European Union. The role of genetically modified organisms in developing countries. Can we feed the world without having recourse to genetic engineering? The issue of cloning and the resolution adopted by the UN General Assembly. The use of embryos for research, therapies, human stem cell research, and so on and so forth. The perspectives for gene therapy, especially human gene therapy. The issues of free trade agreement, TTIP, the discussion on CETA, the Precaution Principle already mentioned. And finally, the issue of patents on DNA sequences and GMOs. From a lawyer's perspective, the core concept is human dignity as far as we discuss interference in interventions which relate to human life, including very early forms of human life, such as the embryo in vitro that is destined for implantation or for other purposes. Now, in the Western discourse, we have come to consider human dignity as a kind of code for defining the elements of personhood and also for an understanding of a natural order of things and persons. And we can consider human dignity as a kind of common roof for a mega diversity of legal and ethical standards. Especially in Germany, in German constitutional law and in German legal philosophy, it is Immanuel Kant's object formula that stands out as a kind of rail that guides us to solve the implications of modern biotechnology with respect to human dignity. And most of you, I guess, will be familiar with Immanuel Kant's object formula that mankind itself has or is a dignity, with the claim that the human person shall never be used as a means, but always as an objective, and in respecting this status, we respect his or her dignity. Arthur Schopenhauer, in his very sarcastic way, tore this formula to pieces, and it's virtually impossible to translate that into English without doing harm to Schopenhauer's sarcasm. Though he says it's a very convenient formula which has a kind of intuitive attractiveness. We shouldn't use the human person as a means. But that when it comes down to concretize it in specific situations, we just get lost, because we find then that it's a very indeterminate formula. It's convenient, but in fact it is of very little practical use. It lends itself to imitation, to copying, to be repeated all the time. And when you open the commentaries on our basic law, you find Immanuel Kant. And whenever you have discussions on in vitro fertilization, on stem cell research, you will always have the recourse to Immanuel Kant. Even though we may wonder whether Kant really knew about these implications. Kant was writing about the born person. Then, of course, we have, that's another perspective, Emile Durkheim, which must be mentioned in this forum. The understanding of human dignity and the sacredness of the human person as a societal phenomenon which builds on religious concepts. All this based on a collective conscience. But again, like Kant, Durkheim didn't write about very early stages of human life. Not even about the embryo in utero. It was the born person, with all his societal, social relationships he was writing about. But still, these are formulas which are still very important, and I will come to this later on again. So when we try to infer conclusions for the status of human dignity, we can distill certain parameters that may guide us, species belonging to mankind. The continuity, is there an inbuilt continuous development? Definitely it's present in the embryo in utero. There's this continuous development, unless interrupted by abortion. But do we have this continuous development in the embryo in vitro? We still need implantation. If we don't have implantation, there will be no continuous development. And that brings us back to religious underpinnings, the role of the mother. It's implantation that brings this very early stage of human life into contact with the mother. And then you have continuity. Then identity. When does early stages of human life grow into a being with an identity of his or her own? And finally, related to continuity, the element of potentiality, the potential to become a human being in the full sense of the word. We have the discussion also when we talk about human dignity. Do we only protect the individual? Or do we rather protect a claim of mankind as a whole? Dignity of the human species. It's very difficult to challenge cloning as a violation of individual human dignity. Because it's not very easy to say, well, whose dignity is really violated? The cloned person? The clone? Well, does the clone have a right not to come into existence? Very difficult. So the argument would run very often, it's a certain concept, a vision and understanding of mankind that does not allow the human person to be duplicated, replicated by way of cloning. This leads us to the religious underpinnings of human dignity. Recalling again the discussion in the German parliament on pre-implantation diagnostics, before we entered the discussion of legal expert, ethical expert, medical expert, biological experts, there were leaflets at the entrance of the hall in the German, and there was the Catholic Church, the legal position of the Catholic Church, very clear-cut and consistent. All kinds of human life is vested with dignity. We cannot allow pre-implantation diagnostics with the objective to discriminate, to select. So there's the understanding of continuous development. Wherever we have human life, we have the presence of the imago Dei, the image of God. That's a very, very consistent, very strict understanding. Although when you go on and ask the colleagues from our faculty, say, does this stage of human life, this being, has a claim to eternity? Recht auf das ewige Leben? That's a very delicate question. Things are, even from such a consistent, strict doctrine, sometimes rather delicate. Then you had the Protestant Church, which would say, well, we must balance interests, protection of dignity, protection of life, but we must understand the parents who have a legitimate interest in pre-implantation diagnostics. That is a dilemma. We must recognize this dilemma. That we have a dilemma we knew already beforehand. But at any rate, it was an admission, a kind of frankness. And there would be a position, a leaflet issued by by some Islamic communities. They would say, well, in the Quran there's nothing about the embryo in vitro. There's no religious problem. So we have all kinds of religious underpinnings when you approach human dignity. Then we can ask ourselves, is human dignity really a concept of positive law, or is it rather a concept of natural law? Almost 2 decades ago, when I wrote something which I found just very commonplace, that any notion that's written in our Constitution is a notion of positive law, including the notion of human dignity. And that we must interpret human dignity as a notion of positive law. This draw very passionate criticism. Because the idea was that is something beyond positive law. Now that leads us into difficult waters. Because if it's a notion that's beyond positive law, who has access to the teachings of that transcends positive law? It must be a kind of natural law. If it's not positive law, it must be natural law. Probably it's just the few gifted and selected persons who have the right access to these teachings of natural law that should be allowed to interpret these notions, and not common interpreters of human dignity as a concept of positive law. My approach would be to consider human dignity as a reflection of collective memories as to suffering and persecution. And I would also advocate a comparative approach as opposed to a nation-centered definition. This is another hotly debated issue. Is there a specifically French or German understanding of human dignity? Should we as Germans define human dignity in a nation-centered approach, in a parochial approach? And you will find that quite a number of interpretations would at least in an implicit way side with this interpretation. But if we talk about the human dignity, the dignity of the human person as such, that would suggest that we are talking about a universal concept. Still, we find quite a number of interpretations of human dignities according to which the British House of Commons is permanently violating human dignity, or the Israeli legislator, or the the U.S. Congress. In my view, the comparative approach at least should teach us some kind of modesty. We should take care what other democratic institutions say when they approach certain issues with respect to biotechnology. Now we come to a very controversial issue, that is human stem cell research. In Germany, we have a kind of split approach. It's not possible, and that is based on human dignity, to use human life, an embryo in vitro, just for the very purpose of creating human stem cells. Because there perhaps Kant is maybe helpful. In this case, the embryo in vitro is really used as a means to become stem cell material. And that's why in Germany we have opted for banning entirely the production of human stem cells. Still, we allow human stem cells produced in Israel, in the United States, in the UK, to be imported and be treated as material for further research. That is, you might call it a hypocritical approach. We allow our scientists to make use of the fruits of the poisonous tree. But still, I do think we have to recognize that sometimes we have to approach things in a way that's not entirely consistent. Perhaps there are some inbuilt limits as to consistency, as this very case shows us. We have a very famous colleague and researcher in the area of stem cell research, and he was one of the protagonists in a very famous case, Bristol against Greenpeace. He invented a procedure for working with human stem cells. And this patent which he got was challenged by Greenpeace. And in the end, the European Court of Justice sided with the objections of Greenpeace in the light of the Biotechnology Directive, which says inventions shall be considered unpatentable where their commercial exploitation would be contrary to public morals, to the public order, ordre public or morality. And this applies especially when human embryos are used for industrial and commercial purposes. And the European Court in Luxembourg held that the embryo in vitro is a human embryo in the very sense of this directive, and that whenever you use human stem cells for a patentable invention, you use it for commercial purposes, because you usually try and get a patent in order to exclude others from the intervention and to charge license fees. And the European Court of Justice went on saying that the use of embryos for the production of stem cells automatically, eo ipso, and always violates human dignity. Now that's the emergence of a European ordre public, and the implications are far-reaching, because what Bristol did was perfectly illegal under German law. He worked with stem cells imported, I think, from the United Kingdom under some conditions laid down in the German Stem Cell Act. And the production of stem cells in the UK is perfectly legal. Still, from the perspective of the European Court of Justice, this use of early stages of human life is a violation of human dignity. That is, it comes down to saying that the freedom accorded to researchers in the UK is a violation of human dignity. Still, we have this verdict, the Stemning verdict, which is controversial, and the practical outcome is, as Bristol doesn't dispose anymore of a patent, anybody can do what Bristol did, because there's no patent anymore. By the way, there are some universities that solicited and got a patent on certain forms of the hydrogen bomb, with a very objective to exclude others to use the patented invention. Another very famous case takes us to another continent, to Central America, to Costa Rica. In Costa Rica, in the late 90s, the government issued a decree allowing parents who have no chance of getting children through the natural way, to have recourse to in vitro fertilization. This government decree was struck down by the Supreme Court of Costa Rica, the constitutional chamber of Costa Rica's Supreme Court. And the Supreme Court of Costa Rica held that in vitro fertilization violates the right to life, because it always implies the production of so-called supernumerary embryos in vitro. You can only implant a certain number. In Germany it's 3, in other countries it's more. But then you have always embryos that are left over. And the question is, what do you do with them? Do you put them in the fridge? Do you dispose of them, as we say? But anyway, quite a number of these embryos never have a chance to get implanted. They cannot realize their potential of developing into an embryo in utero. And the Costa Rica's Supreme Court reached this conclusion in light of the Constitution of Costa Rica and in light of the American Convention of Human Rights, especially the right to life. A couple of years later, a couple challenged these rulings before the Inter-American Court of Human Rights. And the Inter-American Court of Human Rights, which accidentally is also based in Costa Rica, in San Jose, held that the ruling by the Costa Rica court violated the convention, because the right to family life under the convention entitles a couple to realize their wish, their desire to parenthood via in vitro fertilization. Then the government of Costa Rica followed the judgment of the Inter-American Court of Human Rights and complied with the judgment. That is, it reverted to its initial legislation, which was struck down by the Costa Rica court. But then again, the Costa Rica court reaffirmed its ruling, so we have an ongoing battle between two courts, the Supreme Court of Costa Rica, the Inter-American Court, both relying on human rights. You will recall my talking of human dignity and other human rights as a roof for diversity. And this diversity is also reflected in the discussion on gene therapy. We would allow, in most countries, including Germany, so-called somatic gene therapy. Yeah? That the effects of the therapy are confined to the person treated. We have in Germany, in quite a number of countries, a ban on intervention in the germline, that any modification of the genome that's passed on to the next generation is prohibited. Very controversial. Why should there be a guarantee for the permanent existence of severe hereditary diseases? Does our understanding, in light of human dignity, of the natural order, lead us to protect and to entrench severe hereditary diseases? Now let's assume we still haven't reached the point yet where we can successfully treat hereditary diseases with germline therapy, as far as I know. But it's probably just a matter of time, of years. Yeah? And then to say, well, you have to live with this hereditary disease because we cannot allow a therapy that would ensure that your children do not have this disease anymore. That's a very dramatic understanding of the natural order. We shouldn't interfere with the natural order, including with respect to hereditary diseases. Now, bearing in mind that mankind has always fooled around with the natural order. There's hardly any natural order left. The apples, the dogs, they were not in the Garden of Eden. They are the product of human manipulation and cultivation for the last, 10,000, 20,000 years. There were probably no dogs in paradise. There were wolves in paradise.
And snakes.
And
snakes.
And snakes! And snakes. Well, we didn't fool around with snakes that much. And now we have the new therapeutic options. We do not know exactly how to respond to them. That's gene editing. It's something very strange because you do not add a DNA sequence from another organism, you just cut out something. So the person treated, or the animal treated, or the plant treated is not a transgenic organism, because you just edit the existing genome. So much for the issues under human dignity. I now turn to another aspect, risk management with respect to plants, to some extent also animals, but it's above all plants. Genetic engineering is of paramount importance for the cultivation of genetically modified crops worldwide, and here on the maps. They are probably already predominant in North America, Canada, and the United States, and some Latin American countries, a bit in Africa, a lot in China. Crops, corn, cotton, rice, the golden rice, and in Australia. And there you have the island of the blessed. No genetically modified crops in old Europe. Hardly any, just a bit. Because indeed we are a blessed continent. Frostbite, pests, drafts do not affect us as they affect other countries. So we can ensure the livelihood, feeding our population without having recourse to genetically modified GM crops. It's very difficult in many countries of the world. And many scientists take the view that in the long run it will not be able to feed the world without genetically modified crops. And some of you may have read the letter signed by more than 100 Nobel laureates and other scientists, which launched a passionate attack on Greenpeace. Greenpeace, as you might expect, is very much opposed to genetic engineering in agriculture. And they write in this open letter, "Do end your categorical opposition to him. We call upon you to cease and desist in your campaign against golden rice." Because if you go on in your opposition, you might be responsible for a crime against humanity. Because thousands and hundreds of thousands and possibly millions of children will die because of your resistance to genetically modified crops. Now that's a very devastating attack, very sharply formulated, but it shows you the issue, and here you have time this rice, the golden rice, could save 1 million kids a year. Now that's a different planet. That's not Europe. That's another world, where you might probably save the life of 1 million kids by golden rice and other genetically modified crops. Does it have some human rights implications? Survival, right to food, possibly. So we have different perceptions, and we have also different forms of risk management, especially when we compare Europe, also Detlef just mentioned it, a very strict regulation of genetic engineering, and the United States, and I should add the rest of the world. So it's not just Europe on one side and the United States on the other. It is essentially, I'm overstating it a bit, it's essentially the European Union and the rest of the world. The European philosophy is that genetic engineering as such poses a threat to health and the environment. And that for this reason, genetic engineering, the production of genetically modified products, must be subject to specific legislation, because genetic engineering as a process is inherently dangerous. The US-American approach and the approach taken in many other countries would be, let's look at the product. If the product with which we work, which we modify genetically, is potentially dangerous, then we must subject it to legislation and to administrative supervision. But we look always at the specific product. We don't look at the process of production. So these are fundamentally different approaches. And if I understand the teaching of natural science correctly, there is no inherent risk in genetic engineering as a process, which would support the American approach, that you have to look at the products and not at the process. And in Germany and elsewhere in the European Union, we have European and national legislation with subjects not just genetically modified organisms, but all other ingredients that stem from genetically modified organisms to specific legislation. Some of you may have heard of the famous honey case. The Free State of Bavaria cultivated a few fields with genetically modified mice, corn, for research purposes. And then you had an amateur beekeeper, and the bees are flying around, and as a result of the bees flying around, you found traces, very small traces, very small amounts of dead pollen from these genetically crops. Monsanto, it was Monsanto mice in the honey. The pollen was dead, no longer able to reproduce, but still it was there. And the very presence of this dead pollen had the consequence under European legislation that in order to market the honey, to sell it, you would have to go through a very cumbersome process for authorization of the honey as a product that contains ingredients stemming from genetically modified organisms, and to label it accordingly. Probably you wouldn't be able to buy any honey from any of these countries, because there's always the risk that you find some traces of dead pollen in the honey. Now, everybody agrees that there's no health issue in this. They have just dead pollen, very small quantities, but still a specific regime for labeling and for marketing. Now, what is the international perspective in world trade law? What is the perspective in specific bilateral regional regimes? There we have a strong emphasis on a strict scientific evaluation. That's the philosophy of the World Trade Order, the World Trade System, the GATT and the other agreements. Of course, the World Trading System, the World Trade Organization, and its treaties were strongly influenced by the United States from the very beginning. And the United States and other countries siding with the United States had a strong interest in a strict scientific evaluation. Though a country can only rely on a scientifically sustainable risk evaluation in order to prohibit or to limit or to restrain the import of goods from another country. If there's no scientific risk evaluation that is at least sustainable, we are talking about so-called phantom risks. And phantom risk can never justify a country from restraining the free trade in goods. That's the regulatory philosophy, which you find in the SPS agreement and in other agreements. And when the European Union for about a decade took a position that they would not rule upon any applications for the admission of the marketing of genetic modified products, which amounted to a ban on all these products, because if you do not resolve, take no position, or then leave them on the shelf, you cannot market these products. The dispute settlement body of the World Trade Organization held that this violated the European Union's obligations under the SPS agreement. That's the agreement on sanitary and phytosanitary measures that purport to protect human health and animal health and plant health. And it rules that the precaution principle does not trump the requirement of a rational risk assessment. The United States would say, well, we also cherish the principle of precaution. Only we have a different understanding. Our understanding rests on a strict scientific evaluation, and only in cases of uncertainty, of scientifically sustainable uncertainty, the principle of precaution may be relied upon. A German minister of economy once said in context with CETA, "We will never allow any products from Canada or from another country unless they are proven to be safe." Now, you can't prove anything for good, because all scientific insights are subject to subsequent falsification. We thought once scientifically that the sun would revolve around the earth. That was falsified later on. We have certain assumptions about chains of causation which may be falsified. I was taught as a child that the more milk you drink, the better it is for your health. Now science has said that too much milk is not very healthy. So there's nothing as lasting certainty. So what we are discussing here are different variations of precaution: the European understanding and the American understanding. And on the top of it, we have certain developments. The Cartagena Protocol on Biosafety, not ratified by the United States and other countries, says, well, in addition to scientific risk assessment, countries may invoke socio-economic considerations. These are criteria which stand in contrast with scientific evaluation. Societal perceptions. Our people, our consumers just do not want it. It may be safe, but we don't care. We just don't want it. A Minister of Agriculture was a former cabinet, one state in parliament. The German people doesn't want genetically modified crops. We are just opposed to it. It doesn't harmonize with the German character. Well, that's my addendum. We don't want it. That's a socio-economic consideration. Societal perception. Probably as a sociological phenomenon, a correct statement. Bearing in mind that continental Europe is probably the most risk-averse region in the world. That's a thesis I would like to put to you. And if that is so, if we in continental Europe, a bit less so in Spain, much less in the United Kingdom, are very risk-averse, then this risk aversion must be reflected somehow in our democratic processes of legislation. Societal perceptions must be reflected in legislation, in the law, in a democratic society. When I teach a course on biotechnology law in the United States, the American students and the students from other countries, non-European countries, ask me, well, is there a health issue? And when I say, well, scientifically speaking, there's no health issue, honey case, they said, so why should we care if there's no health issue? But in Germany would say, yeah, you never know that pollen might do something horrible to your organism. So that's, I'm overstating it. These are different, we are living on different planets, possibly, in this respect. But let me reiterate, it is perfectly natural and logic that prevailing societal perceptions are translated into legislation under conditions of a democratic order. Finally, we have the issue of patents on biotechnological inventions, again very controversial. Some of you will remember the outcry, no patents on life. The idea that it's something almost obscene to have a patent on life saying, this is my tomatoes, this is my dogs, this is my sheep, because I created it. The discussion on Harvard's oncomouse, cloned sheep, transgenic tomatoes, broccoli with high degree of anti-cancer material. So there are forms of using gene markers in order to cultivate broccoli that accumulates this anti-cancer material. And one very famous case came before the US Supreme Court and was decided just a couple of years ago. Myriad Genetics. Sounds like as if it sprung from a novel. Myriad Genetics. They claimed a patent because they had isolated a gene. And possibly not at the time of isolation, but subsequently, it came to be known that this very gene, this DNA sequence, encodes proteins that are responsible for breast cancer. Now, if you hold a patent on this gene, all kind of diagnostics must rely on this invention that's patented, and you must seek license permissions from the patent holder, and the patent holder will charge a fee for all laboratories that rely on this intervention. That's like a license to print money. And the question was whether under US patent law, which is very liberal, in fact the US patent statute was one of the very first statutes adopted in the history of the United States, and it was drafted by Jefferson. So anything that can be invented under the sun is patented. And the question was, does this apply to a gene, and because genes and the information they encode? And the US Supreme Court said no. Just the mere isolation of a gene is not a patentable invention. It's rather a discovery what's already there. If you synthesize and modify a gene sequence, now that's an artifact, and that's patentable. But the mere isolation does not qualify for patent protection. That's a landmark judgment. Just finding out what Mother Nature has already construed is not worth of a patent. Modifying the product of Mother Nature, that's very, very, very different. By the way, the European legislation in this very case is more generous. Under European legislation, you can get a patent for isolating a human, plant, or animal gene sequence. In this case, and it's one of the very few cases where European law is more liberal than the US-American legislation. Let me conclude with a few final remarks. Are we heading towards universal standards? I'm not sure. We had this resolution on cloning adopted by the UN General Assembly, which said, well, we condemn you the cloning of human beings as far as cloning violates human dignity. Well, this leaves us essentially at the very start, because we want to know when cloning violates human dignity. And the explication was that some Arab countries, led by Iran, sided with a more lukewarm formula because they wished to prevent a stricter formula proposed by some Latin American countries would be considered as a triumph of the Vatican. Of course, the Vatican, Catholic Church, is logically opposed to all kinds of cloning, interference with the person as a imago Dei. But Iran shared initially the position of the Vatican, but they didn't want that the Vatican could claim the resolution as a political triumph. So they sided in the end with a more liberal version. Very, very, very interesting. The European Court of Human Rights in many cases has emphasized that there are different legal approaches. We are not living in a world of homogeneous value judgment, and this entails a margin of appreciation. So a member state can opt for allowing or for banning in vitro fertilization. And I suggest that the Costa Rican case teaches us about the limits of judicial activism, that we must leave space for the democratic process. I referred to this case already in another context, but because it shows us they have two courts, and they rule about in vitro fertilization. And never the people of Costa Rica had any say in it. There has never been a vote in parliament on it. Can it be that these important issues are resolved only by courts? in light of fundamental rights, of a constitution that was written many decades ago, or an international treaty on human rights, which is interpreted in a very different way by both courts? Do we have common ground for rationality and value judgment? I do think that we have some ground for this. There's some basis for rationality, but only within a given objective. The choosing an objective is no longer a matter of rational judgment. The implementation of an objective once chosen is a matter of rationality, as is consistency. And in the end, I would put to you that the cases which we have just discussed suggest some deference to different legal cultures, to different societal perceptions within a very few elementary universal standards. And it may be that this deference to different legal cultures makes this very topic very apt for discussion in a forum dedicated to law as culture. Thank you very much.